Good morning to everyone, South America or some other place that is still morning. So good afternoon for our speaker, Professor Markus, our participants and everyone who is watching us, wherever you are, welcome. My name is Victoria, and here as co-organizers of the working group, I have my colleagues, Daniela and João, and I also have the pleasure to be between friends. So today as debaters, we have Sofia and Ana Flavia. Professor Markus, it's a great pleasure to learn with you today on the issue of how can we ensure the primacy of human rights in trade and investment policies and treaties in the post-COVID era. I had the pleasure of participating recently in the summer course, summer school with a special focus on business and human rights. So it was an excellent summer school and a very enriching opportunity to meet several students and speakers. So I would like to publicly thank you for the amazing opportunity. So about the topic, trade and investment regimes also overlap and interface with intellectual property, transfer of technology, climate change and energy regimes, and any evaluation must address the impacts of regime convergences, divergences, and intersections on the realization of human rights. So we will certainly have a very interesting debate about the importance of human rights perspective in the trade and investment context. So I would like to publicly thank the audience because since the first webinar, we have had the joy of counting on the participation of friends, colleagues, and professionals from Brazil, but also from other countries too. Just remind that all of our webinars are recorded and available on YouTube if you want to recommend it or even watch later. So you are part of this initiative and you are all invited to keep joining us in our next events. I'm gonna quickly present our speaker now. So Professor Markus Krajewski is Professor of Public Law and Public International Law at the University of Erlangen-Nuremberg, Program Doctor of the MA in Human Rights, Chairperson of the Interdisciplinary Research Center for Human Rights, Chair of the Board of Trustees of the Hermann Institute for Human Rights, Secretary General of the German branch of International Law Association. Professor, thank you so much for accepting our invitation. And after your presentation, we will open a quick panel for questions. Our participants, please feel free to elaborate and bring your own remarks. Wish you all a great webinar.
Thank you very much. A very good morning to everyone in the Western Hemisphere and good afternoon to others. It's a great pleasure to be with you. Of course, one would always wish that one could do these things in presence, but I suppose if we were required to do them in presence, we probably wouldn't be able to do them at all because they would be too difficult to achieve. So it's great that we have this opportunity and this technology. I'm also very happy that I can speak about a topic on which I've spent some time working on and which is, I always consider it to be part of the business and human rights agenda in a larger sense. If you speak about business and rights in a more narrow, in a more technical sense, obviously you speak about the guiding principles, you speak about treaties, you speak about maybe national laws, but I think if you speak about investment treaties, trade treaties and human rights, then it's part of the agenda broadly speaking. And many of you may have seen the most recent communication from the Working Group on Business and Human Rights, which came out with a number of proposals and suggestions, specifically regarding, of course, international investment agreements. So ever since then, one should say, at least since then, there's a legitimacy to talk about this topic. But of course, it was part of the agenda beforehand. I've prepared a couple of slides just to structure sort of my presentation a little bit and also to sort of make sure I don't forget anything that I consider important. And I'm, of course, more than happy to share those slides afterwards if anyone is interested. But again, they just are a basic structure. So you see that I've taken the title and I shortened it a little bit, ensuring the primacy of human rights in trade and investment policies and treaties. I omitted deliberately the post-COVID part of it, even though I'm going to talk about it, but I think it is something that obviously we discussed also before COVID-19, and that sort of becomes, I think, even more pressing in the COVID or post-COVID times. But I still think that many of the questions that we are discussing are not specifically linked to COVID-19, but I'll come to that in just a second. So what I wanted to do is firstly speak briefly about sort of where I see areas of conflicts between human rights on the one side and trade and the trade and investment regime on the other side. And I apologize if I'm saying things that everyone in the room knows already. It's always a little bit a challenge to present these points to an audience where some of the members of the audience may have discussed and researched on these issues already for quite some time, and for others it's still a new topic. So please be patient if I'm saying things that you've heard many times before. And then obviously when we establish that there have been conflicts, I want to discuss policy options I call them policy options to protect human rights, or to, as suggested in the title, to ensure that human rights prevail when there are real conflicts between human rights and the trade and investment regime. And there are basically four sort of areas that I want to look at. The first is, of course, reforming the trade and investment agreements themselves. That's an ongoing, much longer debate already. I also want to spend a moment on reflecting how we can increase the relevance of human rights in specific dispute settlements, specifically, of course, investment, state-investor dispute settlement, but also in trade dispute settlement. I will then touch upon possible elements for a treaty on business on human rights. Many of you will know that I believe it is next week that in Geneva there are discussions within the open-ended intergovernmental working group on establishing a legally binding instrument on business and human rights. And I think this is also an area or an arena in which these topics will be discussed and should be discussed. And then finally, I will also have a brief look into domestic constitutional law, because I think in the last couple of years, we've seen some quite interesting developments there. And so it's worth reflecting on what role domestic constitutional law and constitutional review can play in this particular context. And then I will come up with hopefully a preliminary conclusion. Now, I'm going to speak maybe for, I suppose we agreed on sort of 20, 25 minutes or so, but obviously since we are a small group, I'm also very happy to take up questions when they come in between, if that's okay with the moderator or okay with the general thrust of this webinar. So let's start with conflicts between human rights and trade and investment regime. And of course, if lawyers talk about conflicts, they often have a rather narrow understanding of conflicts. And I'll say in a moment that I have a bit of a broader understanding. But before I do that, let me very briefly say what I mean when I talk about the trade and investment regime. I deliberately use the term regime because we are looking at a whole network or web, or at least a cluster of international agreements. Firstly, of course, we look at trade agreements, multilateral trade agreements, but also regional trade agreements. I'm just mentioning the WTO, the World Trade Organization, but also free trade agreements, obviously the Mercosur agreement, but then of course also agreements between different states, or as I'm pretty sure you're all aware of, and it's a hotly debated topic, the proposed free trade agreement between the EU and Mercosur. That would be, of course, all trade agreements that one would discuss in this particular context. And the second part, or if you wish, or element of this regime are, of course, investment protection treaties, most of them being bilateral investment treaties, some of them also regional investment agreements, regional investment protection agreements. And of course, we also have a number of investment protection chapters in free trade agreements. And that's why I rather call it a trade and investment regime, and not look specifically into individual agreements. Now, if one talks about the regime in a larger sense, of course, one would also need to mention export credit agencies, investment promotion insurance agencies, or other policy instruments at the domestic level, which are aimed at promoting trade and investment. For the purposes of this presentation, I will leave this out, but of course, in the discussion, we can also come back to that if that's of any interest. So basically, we also, of course, need to realize that when we look at the trade and investment regime from a general public international law perspective, one specific element is that most of these agreements, largely speaking, have a relatively effective dispute settlement. And of course, the most effective of these is the investor-state dispute settlement system, the system in which investors have the right to raise claims against host states with the argument that an investment treaty was violated. But I would say, at least until very recently, and maybe that's changing again, we also have a relatively effective dispute settlement system at the WTO level. Those of you who know a little bit about this will know that in the last couple of years, at least the appellate body has become dysfunctional due to a number of policy developments in the WTO, but it's not entirely unlikely that that system will become effective again. So I guess the point I'm trying to make here is when we look at these agreements, we need to be aware, not just look at the agreements themselves, but specifically also look at the dispute settlement system, because that's how these agreements are being interpreted and that's how these agreements are being implemented. Now, one feature, and I think this from a conceptual perspective for me is quite important, when we look at these agreements, we need to understand what they actually contain. And typically, they contain prohibitions of what I would call certain state measures. So they prohibit a state from raising a certain tariff. They prohibit a state from imposing import quotas. They prohibit a state from treating an investment in an unfair or non-equitable manner, or at least in the context of investment agreements, they require compensation. So the regime, the trade investment regime, is very measure specific. It tells a state, when you do your trade and investment, your economic policy, these are the kind of measures that you cannot do, that you cannot take. I'm underlining this because when we look at the human rights regime, we will see that that's actually a little bit different. When we look at human rights, of course, apart from the obligation to respect human rights and to refrain from certain activities in our particular context, when we look at human rights, we of course look at the requirement from human rights treaties of states to regulate businesses or even to intervene against business activities. And that's what in the human rights context, of course, we call the duty to protect. And here again, it's basically human rights treaties do not specifically tell a state you need to raise tariffs, or you need to impose a certain ban on something, or you need to expropriate maybe an investor. Human rights treaties tell the states you need to protect the human rights of individuals against activities of businesses, and how you do that is more or less up to you. So, and I think that's important to see that structural difference here between investment and investment and trade treaties on the one side, and human rights treaties on the other side. And of course, when we look at that, we will see immediately that the obligations of trade investment agreements may actually reduce the policy space to ensure human rights. And I'm just mentioning maybe 3 examples here, which many of you will also know from the debates or the literature, and Victoria also referred to some of them already. First, of course, being intellectual property rights, which we have in most, if not all, trade agreements. We of course have the TRIPS in the WTO, but we also have TRIPS plus obligations in free trade agreements. And these intellectual property rights, or the protection of these intellectual property rights, may of course impede the production of generic medicines, because generic medicines or the production of generic medicines may be infringement on a patent right, and therefore intellectual property rights would impede that and have a negative effect, of course, on the human right to health. You can think of tariff reductions. A tariff reduction may increase imports, which may destroy local agricultural markets. We've seen this particularly in the case of sub-Saharan Africa, but also in many other situations. And that, of course, can have a negative impact on the right to food. Or the price cap for water and electricity may be considered a violation of the fair and equitable treatment standard of a bilateral investment treaty, and that may have a negative impact on the right to adequate standard of living. So what we're seeing here is that these obligations from these trade and investment agreements reduce the possibilities of states to regulate, and I would say they infringe on the duty to protect that comes from human rights treaties. Now, when we accept that there is some form of a conflict, the question is, of course, can we say something more specific about the relationship between human rights and the trade and investment regime? And of course, here we need to understand and accept that, at least when we look at it from a sort of traditional classic public international law perspective, there's no formal, and here I mean no legal hierarchy between norms of one treaty and norms of another treaty, with the exception, of course, of the norms of jus cogens. But as you all know, international law is a law which has hardly any hierarchical relationships, and therefore the treaties such as the International Covenant on Economic, Social, Cultural Rights, or the Inter-American Convention on Human Rights, on the one side, has the same legal hierarchy, so to speak, that same legal rank, the same legal rank as a trade or investment agreement. And we will also see, and this is the point I wanted to make, we will see there are usually no formal, no legalistic conflicts. And I think that's important because normally when we discuss conflicts in international law, our reaction is, well, is there a lex specialis rule? Is there a lex posterior rule? Those are the kind of legal techniques that we would normally apply to legal conflicts. But we need to understand, when we look at the human rights regime and the trade and investment regime, we're not looking at that kind of conflicts. We are looking at what I call programmatic or policy conflicts. Because basically, and this is the point I wanted to make, the human rights, the policy, the program of human rights treaties is to enable states, to require states to regulate and to use regulatory space. Whereas the program or the policy of trade and investment agreements is to actually limit that space. And that's when we have this particular conflict here. And we can see it in something called the regulatory chill effect, which is something that's been discussed a lot in the literature, that states refrain from certain regulations, refrain from certain policy measures because they are afraid that that might be in violation of an investment treaty, and therefore they may have to pay compensation, or they may already go into some kind of regulatory arrangement in which they already compensate industry before they even regulate. And that again can have negative effects on the possibility of the state to protect human rights. There's also this idea of locking in liberalization commitments. That's specifically something that we see when trade agreements have something on services and investment liberalization, when countries promise to open their market, to abandon public monopolies and so forth, then they put these commitments into the trade agreements, and that's sort of, then they are locked in. And if there's going to be a new government or new domestic policies, then that may not be possible to change them. And then, of course, what's important in this context is that the interpretation is left to the dispute settlements institution, which have a trade and investment expertise. And I'll give some examples of that in just a moment. So again, I see this particular conflict. I see this particular problem when it comes to regulatory space. And of course, that's also something that we find in the guiding principles on business and human rights. As many of you may know, Principle 9 states should maintain adequate domestic policy space to meet their human rights obligations when pursuing business-related policy objectives with other states or business enterprise. That's a bit of an abstract way of saying it, but basically what our Principle 9 looks at is investment treaties. And here it says investment treaties and investment contracts but the commentary to Principle 9 says that it's of course also trade and investment treaties. So I think, if you wish, from a UN GP perspective, Principle 9 is sort of the principle on which this discussion that we're having here is based on. Now, when I said that a particular problem is the practice of investor-state dispute settlement, I think I need to explain, at least to those who are not familiar with this particular system, what it actually is. It is a system which comes from, basically, or originates, I should say, from private commercial arbitration. So basically, as many of you may know, when two businesses, two companies, two large enterprises have a conflict, instead of taking that conflict to a domestic court, they can take it to arbitration. And then usually you would have one arbitrator appointed by one side, another arbitrator appointed by the other party, and the third usually selected as a neutral sort of presiding arbitrator. That's the technique or the dispute settlement technique that investor-state dispute settlement is based on. But because of this particular type and this particular mindset, we have a lot of ISDS tribunals or ISDS panels which are really reluctant when it comes to taking on board human rights arguments. And there are a couple of cases. One case is von Petzold and others versus Zimbabwe, in which a number of NGOs submitted amicus curiae briefs highlighting the rights of indigenous peoples. In this particular case, this was a case about expropriation. And the tribunal rejected that because they were basically saying, this is outside of our jurisdiction. We are just looking at what we find in the investment treaty. Another famous case is Urbasa versus Argentina, in which Argentina filed a counterclaim based on the right to water, but that was rejected because the argument was that the right to water could not be fulfilled by a private entity. And I find that sort of decision particularly interesting, because you can see what happens if you allow sort of commercial lawyers to start thinking about human rights. I think there are a couple of, I even want to say, doctrinal mistakes in the main part of the Urbasa judgment when it comes to discussing human rights. Very recently, some of you may have heard, just about a couple of weeks ago, we had another judgment, Eco Oro versus Colombia. This is a case which concerned the prohibition of a gold mine in high area wetlands in Colombia, a Canadian gold mining company. And here again, a couple of questions came up. Again, amicus curiae submissions on international human rights law were rejected. And one interesting part of this tribunal was in particular that the Colombia-Canadian bilateral investment treaty did have a general exception clause which allowed states to deviate from the agreement or from the obligations on the agreement if they had sort of a national policy issue. And here the tribunal came up with the argument saying that this general exception clause does not preclude the obligation to pay compensation, which I find is very interesting, because you're basically telling the state, look, you have an obligation, you even have an exception to that obligation, but even if that exception to the obligation sort of prevails, you still have to pay. And I mean, I don't know how it is, I'm pretty sure it is similar in Brazilian tort law, but if you have tort law and you basically say someone is justified, a tort is justified, you wouldn't say at the end, it may be justified, but you still have to compensate, right? So I think the panel really came up with an interesting, I want to say strange way of interpreting the general exception clause. What I find remarkable here is, and I noted that on the slide, this was a highly diverse tribunal that decided, and we had 3 arbitrators, and only 2 of them decided that the defense, based on the general exception clause, would not preclude to pay compensation. And those 2 were the 2 which are more or less commercial arbitrators. The third Professor Philip Sands from London, from University College London, who is also a human rights lawyer, did not join that argument, and he was actually making a different argument. So one can see, and I'll come back to that, one can see that it really is important who sits on these tribunals. Okay, so this is generally when it comes to the trade and investment regime and human rights. Now, what's specific about investment and trade treaties in I put the post in parentheses. I don't know how it's in Brazil, but certainly in Germany, I wouldn't consider us to be in a post-COVID era yet. But of course, hopefully, and we all pray or whatever we do, but we certainly all hope that there will be eventually a post-COVID-19 era sometime. Sorry? Okay. And of course, there's been a significant impact of the COVID-19 pandemic on global trade and foreign investment flows to start with. And I think that's important to point that out, because it also means that those actors, businesses, but also states or business associations who are specifically pushing for investment and trade treaties, they are impacted significantly, just like all of us, by the COVID-19 crisis. And therefore, all the discussions we're having in this particular context will, of course, be exacerbated in the light of COVID-19. So I think what we really see is, when we look at our question from the perspective of COVID, we can see that the general problems that I just described are, as in many COVID-19 situations, exacerbated. And the two examples I want to give, and I'm pretty sure you've all heard them, is of course that TRIPS and TRIPS Plus obligations are seen or are obstacles to produce and distribute COVID-19 vaccines and medicines. And you may have heard that there's debate in the WTO about a TRIPS waiver, in which basically the states would allow deviation from the TRIPS obligations to produce COVID-19 vaccines and medicines. I think it's very important to point out that, at least from a technical perspective, a waiver in the WTO would not be sufficient, because you do have TRIPS obligations and sometimes even TRIPS Plus obligations, meaning obligations going beyond the TRIPS standards in the WTO in many free trade agreements. So one would actually have to look at them as well. And when it comes to investment treaties, we've seen even some law firms advising or pointing out or suggesting to their business clients that they may use investor-state dispute settlement. They may raise investment claims against measures taken by governments in reaction to the pandemic. Many governments, I guess most all governments, at some point resorted to things like lockdowns, shutting down parts of the economy. And of course, that often had negative impacts also on businesses and also on foreign investors. And I'm pretty sure you have similar debates in Brazil, but there are debates all over the world as to whether these measures that were taken by governments are sufficient or maybe not sufficient, whether the government should have taken more or less. And so, of course, one can see that there is a potential, at least, for investor-state dispute settlement claims against these measures taken. So the point I wanted to make is that, again, the general picture doesn't change when we look at the situation from the perspective of a COVID or post-COVID-19 era, but the problems are basically highlighted, underlined, in this particular context. Okay, now I think the problem becomes clear. Are there options to solve them? Now, of course, the first would be to reform the trade and investment agreements. And of course, reforming could be done with a number of objectives. First, one could try to clarify and limit the scope of standards of protection in trade and investment agreements. I mean, many of these investment agreements have rather broad, rather vague standards of protection: fair and equitable treatment, indirect expropriation. But one can also think about terms in trade agreements, non-discrimination, and so forth. So one objective of reforming these agreements could, of course, be trying to make these standards more limited, but also clarify them further. One could also specifically look at the ISDS threat and try to limit that potential by maybe also reducing the options under which one investor can resort to investor-state dispute settlement. One could discuss incorporating a human rights exception clause. This is something that I've been advocating, but looking at the eco oro arbitrary award, I'm not so sure whether these exception clauses would actually really convince tribunals. One could, of course, also establish investor obligations in investment agreements. You could either have a refusal of access to dispute settlement in case of human rights violations, that would be the so-called clean hands doctrine, or one could actually have positive investor obligations concerning human rights and environmental protection as directly binding norms in these agreements. So that's possible. These are the kind of objectives that, of course, states could pursue. Next question then would be, well, how can they do that? Now, if you have agreements which do not have investor obligations, or which still have a very broad scope for investment treaty, investor-state dispute settlement, of course, then one may think about terminating existing agreements. Obviously, one can unilaterally terminate them. One can basically just withdraw from these agreements, but there is a problem, and that's the problem of what some people call the survival clause. Others call it the zombie clause in many of these bilateral investment treaties. And there's a specific element in there saying that even if a state unilaterally terminates an agreement, the effects of the agreement, specifically the rights of the investor to resort to investor-state dispute settlement, continue for another 20 years or so. So even if you terminate an agreement today, there's still this threat of another 20 years of investor-state dispute settlement claims. And in addition, of course, some governments at least fear a negative signal effect that if you terminate these agreements, then you may be sending sort of the wrong signals to the investor community. And that's why some others have suggested, well, it's better to bilaterally or even multilaterally terminate existing agreements, but that, of course, requires the consensus of all parties. And if you do something bilaterally, then, of course, you need to agree, and it's even more difficult multilaterally. In Europe, we currently have the debate as to whether and how we can change the Energy Charter Treaty, which is also an investment protection agreement. And even though there are a lot of countries who want to sort of change it, or maybe even terminate it, a multilateral changes would, of course, require consensus. Again, one can renegotiate the agreement. That, of course, also requires a consensus. Or when one negotiates new treaties, certainly those should be based on what is called a human rights and sustainability impact assessment. And there is actually a set of UN guiding principles on human rights impact assessment of trade investment agreements, which I find rather helpful. They have been produced by Olivier de Schutter when he was the special rapporteur for the right to food. But it's still quite a useful document there. There are also a number of new models proposed by the United Nations Conference on Trade and Development, UNCTAD, think tanks, NGOs, and so forth. So there's a lot, of course, to be done in the context of when one actually negotiates new treaties, and we've also seen some changes there as well. That, of course, doesn't solve the problem of existing treaties and doesn't solve the problem of the interpretation of existing agreements through dispute settlement bodies or dispute settlement tribunals. So that, of course, then raises the question, well, how can we increase the human rights relevance in dispute settlement? And here, I need to stress it again, we need to really take into consideration that the professional background of these arbitrators is often economic and commercial law. And you're sometimes surprised. Obviously, everybody thinks they know what human rights are, and everybody thinks they know the doctrine of human rights law, but then you are very surprised as to what they actually make of it. And for them, you know, you can really see it's a strange field of law, and they don't want to touch upon it. Another point, which is not so often discussed in the literature, but I think it's nevertheless very important, is when if you think about arbitration, basically, or an arbitral tribunal would basically speak to the claims and the arguments that parties make. And of course, the investor will either claim its own human rights, but certainly not claim human rights of affected stakeholders. So that would be the state. The state would have to bring those claims to the dispute settlement, but states are reluctant to do that. And I think there's a structural reluctance, and the structural reluctance is basically what you are asking the state is actually to make the argument that the state itself failed to ensure the human rights. I mean, this is something that I thought was quite interesting when one looks at the Argentina water cases. I mean, there are a number of cases that have been adjudicated on the basis or against Argentina regarding water policies. And it took Argentina quite a long time to finally engage in a human rights argument. And I think that's because otherwise Argentina would have to have argued that, look, this is also a human rights issue. We want to regulate, we cannot regulate. This is the problem. And states usually don't want to make the argument we are the weaker part in these settings. So that's why I think one needs to look at two things. First of all, one needs to appoint arbitrators with a human rights expertise. But again, the state party is can only appoint one arbitrator, right? So the investor appoints the other arbitrator. And then the third arbitrator is often considered the neutral one. So if you look into the Ecuador dispute, Colombia appointed Philip Sands, who then brought in his human rights expertise. But of course, the investor appointed someone else, and they agreed also on a commercial lawyer as the presiding arbitrator. So again, I think here states need to push more and try to have more arbitrators with actually take these arguments into account. And then secondly, one should think about how one can allow affected stakeholders to present their human rights claims. Often this is done through amicus curiae briefs, or sometimes also through counterclaims. But that, of course, requires, when it comes to amicus curiae briefs, requires the willingness of the tribunal to actually accept those amicus curiae briefs, or if you're really talking about raising counterclaims by affected stakeholders, affected communities, indigenous peoples, or so forth, then obviously you would need to change the treaty. Let me come to the third element of sort of remedies, and that's potential elements of a treaty on business and human rights. As I said at the beginning, many of you may know that the Human Rights Council established an open-ended intergovernmental working group to elaborate a legally binding instrument, LBI, to regulate enterprises in human rights law, or as our friends in the NGO community usually call it, the binding treaty. And as a public international lawyer, I always get a little bit of a shiver if I hear the word binding treaty, because of course all treaties are binding. Or something they say the UN treaty, as if there would be only one UN treaty. So let's call it the legally binding instrument. There have been discussions and proposals on that since 2015. And you may know, of course, that there is a third revised draft out since the 17th of August of this year, which will be debated next week. And of course, but it doesn't have any direct obligations for corporations. It has obligations for states to regulate and to provide access to remedies. But, and this is the point I wanted to focus on here, is it also contains some basic rules on compatibility of trade investment treaties with human rights in Article 15.5. I don't want to go into the details of that, but I think if one discusses amendments to that, I think there are a couple of points that could be said. One could amend Article 14.5 by requiring states to conduct these impact assessments based on the guiding principles, the UN guiding principles on human rights impact assessment. And what's important is you need to do these impact assessment, of course, before the negotiations, before you start, during the negotiations, when you've already sort of agreed on certain elements to know which course to take, then of course before the ratification, and I would argue even periodically after the entry into force, because you want to know how the agreement actually works and what kind of impact it has on human rights. And the other element would again include a specific exception clause, which would allow states to fulfill their human rights, the obligations on human rights treaties with measures which would otherwise violate their obligations under the respective trade and investment agreements. So I think Article 14.5 of the legally binding instrument as it stands right now is a good starting point, but there could be done more. And if anyone is interested, CITSE, which is the sort of association of Catholic relief agencies, broadly speaking, they've commissioned a study on the third draft, in which I sort of point out what or how one can sort of amend Article 14.5. Last point, then be very brief, domestic constitutional law. Now, this is a development which I must say we've really seen only in the last, I want to say, 5 to 10 years, which is interesting, of course, because I mean, most of us have gone to law school or are still in law school, or so actually constitutional law is something that we all should know about. And of course, it's very clear that constitutional law would or could at least, of course, provide conditions for international agreements. I mean, you could have in your constitution certain requirements, certain conditions when a state can enter into international agreements. And you could also say that even the human rights, the basic rights that you may have in your constitution, are conditions for international agreements. Now, most constitutions, at least most constitutions I'm aware of, do not formulate specific foreign policy obligations, but of course, constitutional law can be interpreted, and then one could also derive certain conditions from constitutional law. That, of course, requires that constitutional courts can review international agreements, and you may know that the Constitutional Court of Colombia, just about 2 years ago, in a quite interesting judgment, reviewed the Colombia-France bilateral investment treaty and came up with sort of an interesting, innovative element. It said it sort of it came up with this idea of a pending constitutionality. So it didn't say it's unconstitutional. It also didn't say it's constitutional, but it required Colombia to have a number of additional instruments, which then would lead to the constitutionality. So of course, constitutional courts would either declare an agreement to be constitutional or unconstitutional, or require amendments or certain declaration. That again depends, of course, on the consensus of the parties. So I think we need to be very clear that what constitutional law and constitutional courts can do is only to give instructions to one party of an investment agreement or of a trade agreement. And of course, then it is up to the state how it then actually implements those rulings or those conditions by constitutional law. So let me conclude. When it comes to ensuring the primacy of human rights vis-a-vis trade and investment regime, we should be looking at a plurality of instruments. We should be looking at international and domestic legal instruments, treaty changes, legally binding instrument, constitutional court, constitutional law. We should also look at policy changes by states or by governments, I should say. I think that's very important. And also which government agency, which ministry is in charge of negotiations of these treaties, but also then leading these or engaging in these investor-state dispute settlement tribunals. And then finally, of course, we need a change in the attitude of lawyers and arbitrators, because those are the ones who actually bring claims, and those are the ones who actually then interpret these agreements. That concludes my presentation. Thank you very much for your attention. I hope I've given us some food for thought, some questions, and I'm now very much looking forward to the comments and the debate.
Thank you so much, Professor Markus, for the enlightening and detailed presentation. You asked about the COVID situation here in Brazil. We saw daily decrease in the number of deaths. And we are already talking about third shot for healthcare professionals and also for senior and elderly people. So hopefully we can say about a post-COVID era soon. I'm optimistic. So about the topic, I have some concerns regarding especially the direct obligations towards corporations. But before I present my own question, I would like to greet our audience from several countries here. Really great pleasure to have all of you here today. You are also part of this initiative, and your participation makes all the difference for us. So to start our reflections, I would like to invite our debaters, Sophia and Ana Flavia. And please, all of our participants, feel free to present your questions to here, opening the microphone and camera, or even present it on the chat.
So if I may go, Ana Flavia. First of all, thank you very much, Professor Markus. It's a pleasure hearing from you, getting to know a little bit better from international law, which I confess is sort of always a mind-blowing thing for me. I think the intersections and the relations are really complicated and show us how globalization can increase what we already know as domestic constitutional problems, for instance. So here I will not talk or not do a direct approach of the content from trade agreements and treaties, but more I'm relating more to what you said about how dispute settlement plays a great role in the interpretation of these agreements, and how actually we've been the development of capitalism and globalization has been increasing in the past decades. And at this point, I cannot help but think that some of the trade and investment agreements do not deal with the complex economic relationship between countries and this inevitable intersection with human rights. So I'm aware, of course, of the difficulties regarding this, a new negotiation of those treaties and how this structure has been functioning since, well, with full force for 20 years now. But my question is, wouldn't the faster way, not the easiest one, because I don't believe there is an easy way here, but maybe the fastest way would be to provide dispute settlements with new structures. So you mentioned stakeholders here. And when we talk about the role, the role from states regarding protection of human rights, I also can't help but think that states, as you mentioned, sometimes fail to protect. I'm not saying promoting here. I would go too far, but states fail to protect human rights, and it would be, well, from an investor's point of view, it would be a bit of a hypocritical approach to say, well, you cannot violate human rights when the state is not fulfilling its role. So I would like some comments, some remarks on the role of stakeholders here, if it could at least provide a new perspective in dispute settlement, if we have, from an international law point of view or perspective, a chance of seeing that taking place, especially in this post-COVID era. I think You also mentioned the waiver of intellectual property rights, which at first seemed very great news for everyone. It was maybe a historical moment and could, or maybe will, open space for change, let's put it that way. So considering this global impact of COVID and maybe a new era for capitalism itself, and of course for trade investments, what can we expect from stakeholders in that sense?
So, Professor, do you prefer to answer one by one, or even we make a collective panel of questions?
I think that it's more interactive if we collect some questions. I'm taking notes.
Okay, so Ana Flávia, please feel free, the floor is yours.
Okay, thank you. Thank you, Professor. It was very enlightening, your presentation. And it got me thinking a little bit about the hardships we have when we decide to enforce human rights on all those treaties. And two things caught my attention, and I would like to hear you talk a bit more about it, if you could. First of all, you said a good strategy would be to make an impact assessment on human rights concerning those treaties. And I was wondering what indicators could we use, and if you have an example of a successful use of this assessment in previously to the agreement, in one case that maybe the agreement didn't go forward, or if how the agreement clauses changed along the time. And one obstacle I see is that sometimes countries, they depend on these international investments, and some companies, they have more geopolitical power or maybe even more resources and money than whole countries. So how can we, how can I say, balance the power between those two parts of the treaty in order to really enforce human rights policies and principles? Thank you.
So, João, would you like to present the questions?
Hello, Professor. Thank you very much for our inspiring presentation. Something that I would like to ask you is what are the outcomes when you think of this new draft of the Biden Treaty? If we not expect direct obligations towards business, and we all know that businesses are the most prominent actor responsible for human rights offenses in a globalized world, as Sophia has said before. And so, what do we expect if not direct, if we not have direct obligations towards businesses? So, what do we have instead? Is there another strategy, or are we looking at maybe an omission towards the most relevant forms of human rights offenses? And so thank you very much again for the very inspiring presentation, Professor.
Professor Danielle, please feel free to present your question too.
Right. Thank you, Victoria. Thanks, Professor Markus, for this lecture. It was really, really nice to listen to you. So you were speaking about reforming the agreements, but I would like to go back to actually reforming the dispute settlement institutions, because I really feel that we depend too much on government's will to implement changes on agreements. And on my head, it could be a bit easier maybe to try to think of the changes on the institutions. So of course, and on top of my feeling, there's also your explanation about what happened with Urbase and Eco-Euro cases. So this just reinforces my point on how hard it is to actually change the policy that the states or the governments are willing to implement. So my question is, would you say that maybe what is the best strategy on your view, or would you say that we can fix the dispute settlement institutions to make them more human rights friendly, and then focus on that? Or should we just advocate for the extinction of what we have now and just, create something else from scratch, something completely different? Thank you.
So I have a question too, maybe for this first panel, and I think it's related to Ana Flávia. And so in 2003, 10 of the world's major project finance lending banks adopt a set of voluntary principles called the Equator Principles. So these principles require the banks to ensure that those projects they finance are developed in a manner that is both socially responsible and also environmentally sound. So the significance of these Equator Principles is for human rights is the requirement in appropriate circumstances for the social assessment of projects. So when we think about social impact, however, there is a high difficulty to measure impacts and think about indicators. So, and we know that impact or social change is difficult to measure for so many reasons. I mean, tracking influence or change over time, especially over grand cycle timelines, it's a daunting task. So within an organization, limited measurements can be due to a limited amount of in-house learning, evaluation skills, general lack of time and resources to do thoughtful learning. And in this context, how can we be more assertive in measuring social impacts in the investment context? I would like to hear from you, maybe a few comments about that. Thank you so much.
Thank you. Shall I try to answer some of the questions? I'm not sure whether I'll be able to comment on every detail, but there are obviously a couple of questions which are linked together. Maybe I'll start, Victoria, with your question, and also Ana Flavia's about the impact assessment and about how we actually measure what we are looking at. Of course, I think that's one of the most difficult questions. So my immediate reaction would be, okay, it's difficult, but simply because something is difficult, we should not sort of not do it, right? So obviously it will not be perfect. And I think we should not be looking at sort of the perfect assessment, which will then tell us at the end exactly what kind of treaty we should adopt or not adopt. So, but I think what's important is, so far, most of these impact assessments have been done. Also the one, I mean, Victoria, you mentioned the Equator Principles. So, I mean, there's impact assessments also when it comes to project financing and so forth. Most of these impact assessments have been done before a project has been taken. And also when it comes to the treaties, so the EU came up with an impact assessment of the EU-Mercosur agreement basically before they started negotiating. So, and in that case, of course, your impact assessment will be limited to a very general look at, the situation in the trading partner's country, in your partner's economy, the kind of agreement you normally conclude. So it's going to be a very broad, very vague kind of impact assessment. That's why I'm saying we need to have an ongoing impact assessment. And I mean, one of the problems is, of course, in the course of the negotiations of many of these treaties, the drafts are not made public. Yeah. So, I mean, unlike in domestic legal systems, when you have draft laws and then there are amendments to the drafts, you normally would publish this, and then there's going to be a public debate as to whether one would need this amendment or that amendment. We don't have that in trade and investment agreements, at least not formally. So I think one also needs to call for more transparency in these negotiations. And then, of course, I mean, for example, an area in which I'm a little bit more familiar with is the liberalization of services. So when you would want to agree on the liberalization of a certain sector of the services economy, then of course you would have to have a specific impact on that. and assessment. And here, of course, indicators, I mean, I think when it comes to social and economic rights, we already have a number of indicators. When it comes to the right to health, one can measure things like, you know, a certain amount of hospitals, the number of maternal deaths or what have you, or child death or whatever. So I think there are a number of measurements, but of course one would not just look into sort of things that one can measure, but would also have a broader policy impact assessment, right? And the other thing, which I again think is even more important, is not to say, well, this is the agreement that we have now, and then say, you know, box ticking exercise, but rather say this has to be ongoing. Because in particular, when we look at some of the impacts of sort of trade agreements on agricultural markets, it's only after the agreement was enforced and was implemented did the states realize the kind of effects that would have. And of course, here again, we've seen impact on, you know, the destroying of local markets. And yes, of course, these kind of events are also often multifunctional, multi-causal developments. But still, I think one can point in particular context, if you lower tariffs on canned tomatoes in Senegal, canned tomatoes from Italy will end up on local farmers markets in Senegal and destroy the potential for farmers. So I think there one can make those. And then of course what we need in these agreements is then a mechanism which allows us to react. Because if the agreement, if you say, well, this is a problem with the agreement, then, and you can't do anything, then that's a problem. So I think one would even have to have maybe a monitoring body. And of course, that monitoring body would have to be an independent body. Right? It shouldn't be a governmental body. It shouldn't be a body that sort of has the vested interests of governments. It should be independent and then recommend what states could do. So I think a lot of ideas would have to go into that. But I think one can actually do this kind of impact assessment. But to Anna Flavia, I'm afraid I don't have a really good practice example yet. So that's definitely something that one would need to establish. Now, the second group of questions, I think one was from Danielle and the other also from Sophia, is about the reform of the dispute settlement and what can we do there. And if I understood Danielle correctly, the question was even, wouldn't it be enough to reform dispute settlement or even abandon dispute settlement at all? I'm always, so how should I put this? I'm always a little bit reluctant to proposals. Let's just do one thing and then all problems will be solved. So I think it's more than that. It is a problem who sits on these panels, but it is also a problem of what kind of agreements they're looking at. I think one has to be very fair. I mean, there's right now a debate, at least in the European Union, that all the problems would be solved if we would have a multilateral investment court, because a court is so much better than arbitral tribunals. Now, I have to say, I'm very much afraid of such a court, because if you have an investment court saying things about trade and investment agreements which are detrimental to human rights, it's even worse than having a tribunal. Yeah, with a tribunal, you can say, these are just a bunch of commercial lawyers and we shouldn't care too much about them. But if you have a court getting it wrong, it's a much bigger problem, right? So I think we really need to think about sort of what are the consequences of what kind of instruments we're looking at. And this is why I like the idea of actually trying to empower stakeholders more. Because, and I think, Sophia, maybe this was also the basis of your comment. One of the problem, of course, of public international law is that it's so much state focused. And of course, the assumption is that the state, the government, brings the interests of everyone together. But of course, we know that's not what governments do, right? Governments have vested interests, governments are captured, governments tend to, you know, not just forget about people, but deliberately not take up the interests of certain people. And of course, that's something that we would need to take into account. So one instrument would really be to maybe not give stakeholders the right to raise claims, but certainly the right to be heard, yeah, like third-party participants, more than just sort of, amicus curiae, but really saying, we want to intervene, we want to make our claims. And if you look at many of the investor-state dispute settlement cases in the Latin American context, and specifically I'm thinking, of course, of Eco Oro, but others as well, it was usually often a local community, sometimes indigenous peoples who were affected, and it would have been extremely beneficial if their voices would have been heard in the particular situation. You could also think of trade unions, yeah, workers' representatives. And I think that would also speak partly to this question that Ana Flavia raised regarding the balance of power between states and investors on the one side. Of course, states sometimes, I don't know, but sometimes I pity states and governments because they are so weak against these powerful multinational companies. But then I think, oh, come on, if we look at what states can do in the pandemic, I mean, within hours, they close borders. Within hours, they have emergency powers. So I think we shouldn't really be fooled too easily into this, the states are so weak. I think states sometimes are deliberately weak when it comes to commercial interests. So, but yes, I mean, the power balance is an important question. I think thinking about bringing other stakeholders into the equation would certainly have an impact. Now, regarding the question on what potential outcome the legally binding instrument could have if it doesn't have binding obligations for corporations, I think that was the question, if I got it correctly. Now, that's of course that's a very unfair question, I have to say, because because as you know very well, there was this idea of having binding obligations at the beginning, and it was in the Elements paper, but then Ecuador and basically the states who negotiated dropped this idea. And I think I can see strategically why they did that, because otherwise they would have not even had a draft legally binding instrument, because the group would have been derailed already in 2018. But still, I think there's a benefit for a treaty, even if it just empowers states again and obliges states again to regulate. I think we really shouldn't, I mean, again, of course, it would be better if we, when it comes to the power imbalance, if we would have direct obligations for investors. But we should also be aware of the fact that, of course, even if there would be direct obligations of investors or direct obligations of transnational corporations, someone would have to enforce them. Someone would have to implement them. And who would be that someone? It would be states again, governments, unless, of course, you have a world government or a world court. I'm not so sure whether we really would want that. But so I think we need to, the states will always be part of the equation. And so that's why I think even if the draft that we see right now is probably not the most advanced draft that one could imagine when it comes to obligations of corporations, it's still better than just sort of having non-binding principles such as the guiding principles. And maybe if I may come to sort of, I guess, Sophia's underlining concern, I noted capitalism/system question here. So yeah, I think you're absolutely right. I mean, that's true. I mean, if one wants to explain why we have these investment agreements and why they are so powerful and why one can implement them and why it's so difficult to implement human rights treaties, then of course the explanation is international law reflects the power structure of the world as we have it right now. That's very frustrating. But then again, I mean, yeah, I mean, what's the consequence from that, right? I mean, I remember once there was a debate when someone asked the system question and said, yeah, I mean, everything, you know, capitalism and everything is. And so then the presenter just said, okay, and what should we do now? Go to the streets and burn all the cars, or what do you want us to do? So I think at the end of the day, of course, at least in the context of law, we are always sort of a little bit restricted to trying to reform the law as it exists, even if it's frustrating.
So thank you so much, Professor Markus. If we don't have any other questions, I would like to thank you for the debate with so many challenging questions regarding the human rights agenda in the trade and investments law. It was a really great presentation that raises us important questions on this topic. So in the name of the Business and Human Rights Working Group, we thank you so much and also for your time. I thank also our great audience, Professor Daniel, our colleagues from Angola, my colleague from the summer school, Hannah, our debater, Sofia, Ana Flávia, our supervisor, Professor Eduardo, and colleagues. We look forward to have all of you in our next webinars. So thank you so much. And thank you again, Professor Markus.
Thank you. It was a pleasure, and keep up the good work. And I hope I can join some webinars in the future as well. And yeah, and I hope there will be a moment when we will all see each other in person.
For sure, it will be a pleasure. Thank you.
Have a good day.
Thank you very much.
Thank you very much, Professor. Have a good night.
Thank,
Bye-bye.
thank you, Professor
Bye.
Markus. Really nice seeing you.
Thank you. Bye-bye.